How's it going? Today's video, I want to look at a case that attracted quite a bit of attention there during the week in the newspapers, and it was an unemployment situation. It was an alleged unfair dismissal, and the case attracted quite a bit of attention because it involved Francis Brennan and the Park Hotel. You know your man there, Francis Brennan. He's got a TV programme, and his brother and himself, they go out and they visit small businesses, small hotels, guest houses, B&Bs and so on, and they give them advice. He also does some sort of a travel programme. During the week there was a case that got a lot of publicity. It was a Labour Court case, and basically the Labour Court heard an unfair dismissal claim by a general manager who had worked in the Park Hotel, and he'd moved apparently from Dublin to Kerry to Kenmare to take up the job as general manager, and I think he was on a 2-year contract. But one day he was brought in by Francis Brennan during the probation period, and it was basically told he was gone, his job was finished, he wasn't working out, and Francis Brennan, the employer, relied on the probation period in the contract, which basically says that during the probation period either party can terminate the employment, and that's exactly what happened. That's what Francis Brennan did. The man then brought a claim to the Labour Court under Industrial Relations Act legislation, and he had to do it under Industrial Relations Act legislation because the Unfair Dismissals Act requires that the employee has 12 months continuous service before he can bring an unfair dismissal claim, and the man couldn't do that in this case. He didn't have the 12 months service. So it went to the Labour Court anyway, and the Labour Court basically said that he, by reason of the fact that he wasn't given fair procedure or natural justice, that he was essentially unfairly dismissed. And the Labour Court recommended that the Park Hotel, the employer, pay him compensation of €90,000. Now, that's an eye-watering sum of money, but he was probably on big enough money in his contract, and the Labour Court may have taken into account the fact that it was a fixed-term contract and there was probably something like 18 months still to run on the contract. The bottom line is the Labour Court recommendation is only a recommendation because it was a case or claim taken under the Industrial Relations Act 1969, and all that can happen there is the Labour Court makes a recommendation. However, it's a legally unenforceable recommendation, and the manager didn't have the benefit of the unfair dismissal legislation to bring his unfair dismissal claim. Now, I've written a blog post about this case, and I've put a link in the blog post to the actual decision itself from the Labour Court. It's worth reading, especially if you have been dismissed on probation. You'll see that there is some options open to you, but they're limited enough. I've written about this before. I've written a number of blog posts about probation and what your options are. So go and have a look on the website. I'll stick a link underneath this video directly to the blog post. You can have a look at it and then you can read the actual decision. But you might think then, or wonder, why would the fella bring a claim to the Labour Court if he's going to end up with an unenforceable recommendation? But he may have thought that the Park Hotel and Francis Brennan would want to avoid the publicity and the reputational damage that's probably going to follow. He probably thought that the employer would want to avoid publicity, and obviously the Labour Court hearings are held in public, and this one has garnered a fair degree of publicity. Now, he probably thought those things, and he may have thought then that perhaps the employer might settle the case or give him some sort of a settlement payment to basically settle the claim and prevent any reputational damage that might arise. I don't know the chap involved, don't know Francis Brennan either, and I can't really understand the motivation without speaking to them, but you can speculate yourself. But the bottom line is he has a recommendation from the Labour Court that's legally unenforceable. And the reason is he could only bring a claim to the Labour Court under the Industrial Relations Act legislation, not the Unfair Dismissals Act. The Unfair Dismissals Act does not apply to somebody who has less than 12 months continuous service. Hope you find this video useful. As I say, I'll leave a link underneath there to the blog post. You can read the actual decision from the Labour Court. It's only 1 or 2 pages, but it's worth a look, especially if you're an employer, and especially if you're an employee who has been dismissed or maybe under pressure during the probation period. You might see something in it that you may be interested in, or you may get some guidance as to what route to go. But as I say, I'll leave a link underneath the video. Hope you find this useful. If you do, give it a thumbs up down below, and you might be interested in subscribing to my YouTube channel if you're not already subscribed.